Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good day to everyone. I am Dr. Ani Munirah Mohamad from School of Law of Universiti Utara, Malaysia. In today's lesson, I would like to talk to you about the different approaches of analyzing contracts. Now, I would like to ask you, have you ever had an experience of being in a family gathering, and when your relatives find out that you're either a lawyer or a law student, they would normally come to you with their legal problems or issues, expecting you to give your legal opinion or legal response in the form of sections or decided cases, or what do you think about the existing legal problem, for example? Okay, now the way we know it. Let me just talk very briefly about as we understand it. Contract law involves a lot of things. Okay, from the point of view of either a lawyer or law students, we would be very familiar with the ways how to analyze contracts by way of analyzing relevant cases and statutes. You know the Contracts Act, you know these relevant sections, you know these decided cases on a specific issue. And you use these cases or statutes to examine how contractual principles have developed through these cases and statutes, and then you're going to give your critical appraisal of the end result. This is something that is normally known as doctrinal analysis, whereby you will be engaging in the legal position, legal situation. You apply that to the legal problem, and then you come up with a conclusion saying that this is how the law sees it, this is how the law puts the position to be, right? However, it is very important for me to highlight that law does not exist in a vacuum, by reason that it interrelates a lot with other aspects as well, such as social, political, economic, historical aspects as well. Law, in order for law to be introduced, there must be a problem surrounding the society. Okay, it could be bottom-up approach from the society that require the law to be created, or it could be a top-down approach from the government side, enacting a specific law which governs the subjects, but most importantly, there are reasons for such law to be created, and once the law is created, it will impact upon the society as well. Okay, now having said that the interrelation between law and other aspects, the intersection between law and other aspects as well, there are other ways in which how we can look at contracts. Okay, within our topic today, there are numerous other ways in which we can analyze contracts. Number one, economic analysis, socio-political analysis, formalism, consumer welfarism, market individualism, as well as empirical research. Now, these six, it does not mean that they do not relate to law, but instead, the decision of the people who have or do not have any legal background, they would engage in other factors in which they will decide to enter or to impose upon a specific contract based on these six factors. Now, let us begin with number one, the economic analysis. Considering the rules of contract in terms of their economic efficiency and consequences. Now, as you may have known that it's a very famous saying that says money is the root of all evils, which essentially, to my mind, what is the saying is trying to relate to us is that a lot of our judgments in this life is motivated by financial aspects or pecuniary aspects, in the sense that what do we get in return for doing something is very often related to economic factors, okay, rather than I'm doing this because the law wants me to do. Now I'm doing this because I can get payment out of this selling of products or services, for example. Apparently, particular decisions about the content of the rules of a contract can have a broader economic influence. Okay, for example, A and B enters into a contract. So what are the terms and conditions imposed upon B as opposed to what are the conditions imposed upon A? Okay, now a lot of the terms and conditions are largely motivated by financial aspects. Now let me just give you a simple example of a consumer contract. First and foremost, product manufacturers should be strictly liable for the quality of their products. So whatsoever that we come up with, okay, whatsoever that we're selling products or services, we must always be responsible of the quality or the suitability of these products to the needs of our clients or customers. Okay, so therefore, bearing in mind the high responsibility that we owe to these clients, so we come up with strict quality control procedures, and also we take out insurance. Now, strict quality control procedures would involve implementing safety measures, safety procedures, a lot of other process and procedure that have to be met by our workers, by our employees, by our contractors, and at the same time we also take up insurance just in case something happens. Okay, so now these would involve costing aspects, okay, because if I were to hire skilled personnel with strict knowledge or appropriate knowledge required for the development and for the production of my products and services, as well as the insurance, then it would inherently cost me some money, right? Now, this money is would hike up and also be added to the product cost. What this means is, in the end, we are going to transfer the costing to the customers. Therefore, greater consumer protection comes at higher prices. If we want better products and services, it would involve additional sum of money which would be transferred to the customers, and in the end, the customers would have to bear additional price in order to get higher quality products or services from the vendors. Now, this is a very classical example of entering into a contract or imposing the pricing for certain products and services based on financial or pecuniary aspects. That's the first factor for analyzing contracts. Now, another example would be excuse me, the factoring of transaction costs as well as factoring of adjudication costs. Now, the first one would involve transaction costs. Standard form contracts are more economically efficient than those that are individually not negotiated. Okay, so that's why we often have very often when you for example, very often when you enter into a bank, okay, you need to fill up certain standard forms because these standard forms have been developed by the bank in order to reduce the cost that would otherwise be applicable if they are individually prepared. Okay, so they come up with thousands and probably more than thousands of standard forms in order to cut the cost from the individual negotiations. Another economic factoring as well is the adjudication cost, whereby fixed rules of law is more economically efficient rather than to leave it to judges to resolve disputes and merits. So there are certain rules of law that are made known to the judges when they are adjudicating cases, whereby these rules of law need not be negotiated or need not be considered or disputed in courts because they are somehow accepted by both parties as well as the judges, and the good side of it is that the judges do not have to discuss or to resolve the disputes on each merits, because there are already the established rules of law, right? Okay. We have a case law for this, is the Photo Production Limited against Empirical Transport Limited. In this case, the court upheld a very widely based clause excluding one of the parties from virtually all liability for breach of contract. So in this case, A and B enter into a contract, and one of the parties it's agreed in the contract that says any liability for breach of contract, any liability whatsoever, will not be imposed on the one of the parties. So first, the issue here is the legality or validity of that particular clause. First, it is said to be based on an assumption that as between two parties freely negotiating, they will have allocated responsibilities and risks in the most efficient way, and so will help maximize wealth. So in this situation, it is the assumption of the courts and the parties that if they freely consent to whatever terms and conditions, it will give maximized wealth, albeit it says, I have these responsibilities and risks, however, I will be virtually not liable for any breach of contract whatsoever. However, the second decision by the court is that the court refused to interfere in a bargain of this kind. Okay, it could, or it may discourage others from litigating, and therefore have the overall beneficial economic effect of reducing transaction costs. Okay, again, the decision by both parties in this case is largely affected by the financial or pecuniary aspects, in which they have decided to come to this situation whereby let's agree to certain things in order we can benefit from this to the maximum. Okay. But the issue now is, what about the consequences of economic efficiencies as well as the issues surrounding it? Okay, for example, it is economically efficient in allowing and facilitating voluntary exchange of goods and services. In other words, the barter system. We give something in return of something, but it's not financial consideration. Okay, the example would be the goods are worth $100 to A, who owns them, but are worth $150 to B, presumably because B can make use of them. Okay, so now A thinks it is $100, but B thinks it is $150. So, if A sells the goods to B for $125, this will be an exchange which will increase the wealth of the society. A will get something extra than what he thinks it should be, and B will pay much less than what B thinks it should be. Okay, so this is in the middle between $100 and $150. So, the economic aspect of it would be maximum wealth for both parties in this case. Right? Now, what do you think of the economic analysis approach to understanding contracts? Do you think it's a viable factor or the viable approach for analyzing contracts? What do you think? Now, second is the socio-political analysis approach when we are analyzing contracts. Now, this approach looks at the ideologies of the underlying contracts. Now, there are a lot of ideologies out there in this world. I don't need to go through one by one. For example, capitalism, Marxism, and etc. Now, each of these ideologies, they have their own teachings, their own understandings and values to its ideology, and a person holding on strongly to each and every one of these ideas would approach things differently based on the understanding or based on their experience in understanding a certain ideology. Okay, now what are ideologies? Because there are these opinions and ideas held on by the parties. What is the intrinsic value of it? Okay, and what is in the mind of the people is what shapes how certain parties evaluate their contracts. They're going into the contract, they're entering into the contract, as well as evaluating the consequences of a contract. Okay, now at some point we all have some political assumptions in the background. Even if we are looking at contract cases purely within their own terms, each individual would have their own values that they are holding on to. Why is this so? Why do you think every person have their own understanding? It's because our understanding about a certain principle could be different from one person to another. It is rather impossible to debate the merits of numerous contract principles without some notion of the value or otherwise of the idea of freedom of contract, okay, which is of course a political concept which have been embedded into the Contracts Act in various jurisdictions, including our Malaysian Contracts Act 1950. Okay, because a contract must be free, must be with free consent, not influenced by any of the vitiating factors, okay, such as misrepresentation, fraud, coercion, undue influence, and all. Okay, so long there is a freedom of contract, then by all means just proceed. Okay, because it is impossible to standardize or to have one formal understanding of the contracts, because there are so many ideologies out there to be considered. Third is the formalism. Now, I don't have to explain details of formalism, because as you can look at it literally, okay, formalism, formal, something that is imposed upon us, okay, in formality. It is an established rule or obligation for the understanding of contracts. So what is the established rule or obligation for the understanding of contracts? It is the formal method to understand things. Wow, okay, this is the formal method to understand things. Example, when a court is obliged to follow rules established in earlier cases, the doctrine of judicial precedent, even if it does not agree with them, it feels that they do not produce the most satisfactory result on the facts before the court. Okay, now, if based on the doctrine of the judicial precedent, so long there are similar material facts between a present case and a case which has been decided previously by a court of higher jurisdiction, then the lower courts is obliged to follow, although he is not happy, the judge is not happy with it, or howsoever unsatisfactory the result may be. Okay, unless, of course, unless the court, the present court can distinguish such decisions, okay, based on the ground of different facts of the case, for example. Okay, all right. That is essentially what is meant by formalism. Okay, in the case of Fox and Beer, okay, the court felt bound to follow what was regarded as an established rule that part payment of a debt could never discharge the debtor's liability for the balance, even if the creditor had promised to treat it as so doing. Okay, so in this case, the facts of the case are quite important in this case, okay, whereby this is a principle of settlement of debt. But what is more important would be the judicial precedent, or the case where the present court decided that it has to follow an established rule of law, okay, because it is the right thing to do. It's the formal thing to do. Okay. Now, number 4 is quite straightforward, which is the consumer welfarism. Even if I don't explain it, okay, you would realize by now that whatever decisions to enter into a contract, whatever decisions to how to treat a specific contract is always giving utmost priority to the consumer's welfare. Okay, law is there to protect people based on the understanding that why is that law in the first place. The reason is it is to protect the people. Okay, for example, when a court recognizes that individuals may be in a weak position as regards dealing with large organizations, then the court would take the step to protect these individuals. And some of these has already been embedded into our local statutes. For example, the Companies Act, protection of minority, and a lot of other statutes as well, which gives the court the power or the strength in order to protect the weak, on the ground that it is to protect the welfare of the consumers. Okay, another example would be the unfair contract terms, when a minority group enters into a contract with large organizations. Normally there would be standardized documents, standardized agreements, whereby in the end these documents are one-sided in favor of the large corporations, but not for the benefit of the minority. The courts would step in to protect the right of the consumers. In these situations, the rules of contract need to be developed and applied so as to protect the consumers. We have a case law for this, which is the case of Kala, Carbolic, and Smokeball. It's a very famous case. I'm sure you still remember what this case is about, where an advertiser was bound by a promise made to consumers who had relied on the advert for the influencer Smokeball. Okay, in general, okay, it could potentially be not binding on the company to make such a payment for the compensation for the client. Okay, but in this case the court cited the principle to protect the consumers because of all the circumstantial evidence from the part of the pharmaceutical company to convince the users on the effectiveness of their medicine. Therefore, the court held that in order to protect the welfare of the consumers, then we will uphold the promise by the advertiser, pharmaceutical company, to make such a payment of compensation to the customers. Other cases would involve the cases of exemption clauses and unfair contract terms, where the courts repeatedly devised rules to prevent large organizations from imposing wide clauses exempting them from liability to people who bought their products and services. Okay, so in this case, the court took the approach to protect the customers, protect the minority clients, minority parties to the contract, because it is the protection of their welfare. Number 5 is market individualism. Now there are 6 altogether and we are already at number 5. Okay? Freedom of contract is the highest priority and leaves the parties to their bargain, even if it appears to operate harshly on one side. Okay, what is important is the freedom of contract. Okay, freedom of contract. The court adopts the role simply of a referee, okay, determining what obligations of the parties must be taken to have agreed to, and then applying them to the situation. In this case, the courts will not step in the shoes of the parties, but instead they will simply become the referee, the middle person who will weigh the rights of both parties, okay, in order to come up with a judgment. A good case would be the Photo Production Limited and Securico Transport Limited, which I have explained earlier on in this slide, as well as in the earlier part of this video, whereby the duty of the judge or the duty of the court is to weigh or to balance between the rights of both parties. And finally is the empirical research. Okay, empirical research, or some people call it empirical research. It is the real world research whereby the parties will look at what actually happens when people make contracts. Okay, rather than you look into the textbooks, you look into the statutes, you look into the decided cases, court cases, or what is contained in the contracts. We actually look at what actually happens when people make contracts. The approach is normally bottom up rather than top down. Bottom up, it will mean from the parties themselves, what they require, what they need. That is something that is the motivating factor for analyzing contracts. Okay, the example of bottom up approach is, instead of looking at decisions of the appellate courts and the rules which they have developed, the focus could be on how contract law operates in people's day-to-day lives. Right? They are the ones living their lives, and such contracts would impact greatly on their respective lives, not on the lives of the judges, not on the lives of the parliament, not on the lives of external parties to the contract, but to the lives of the respective parties to the contract themselves, the disputing parties, the contracting parties. This is what is impacting upon them, so they are the ones that should be given the view in order to say what they need, what they want in terms of analyzing their contracts. Now, this is a question. Does the existence of a particular set of contractual rules affect the way in which people behave? For example, vitiating factors of a contract of undue influence, fraud, and misrepresentation. These legal provisions inside of the statutes, do they affect how we behave, or how we behave we will impact upon the laws? Okay, so the question now comes whether the law actually changes the society. The written rules come first, the court decisions come first, and then the society will follow, or is it the other way around, in which the society comes up with their own standard practice, etiquette in customs, okay, whereby they are the ones which shape the law? What do you think? Yeah. Here's another question. Do businesses have contractual principles in mind when they enter into agreements? Okay, because businessmen not necessarily have the legal background or legal knowledge. So when they enter into a contract, for example, this is what we want based on financial aspects or financial factors, do you think they have the contractual principles or contractual terms and conditions when they actually enter into agreement, or they would normally hire a lawyer to advise them on what is to put into the agreements? What do you think? Another question, when things go wrong, to what extent does the law influence the way in which disputes are resolved? As you can see in this entire presentation that I have made today, when things go wrong, not only the law will influence the way in which disputes are resolved, but in fact, there are multitude of other approaches in which we can analyze contracts. Some of them are economic factors, some of them are ideology factors, some of them are empirical research, for example, empirical analysis, which would actually mean law does not exist in a vacuum. Here's a point to ponder. Where parties to a long-standing business relationship find themselves in a dispute, the maintenance of their relationship is likely to be much stronger influence over the way they resolve their differences. Then, this is a strict legal rights. Over the way they resolve their differences, then are the strict legal rights between the parties as determined by the law of contract. Okay. Now, what I want to highlight at this point is that when there are two parties, A and B, who have been in business for quite some time, they come to a hiccup in their relationship. What could be the possible way of handling this hiccup or dispute between these two parties? Is it the law, the legal provisions, the cases? But it is proven that if they still have in front of them a huge opportunity for conducting business, then they might not go for the legal provisions. Instead, they would like to maintain their relationship, and so that they can have stronger influence over how they resolve their differences. Probably they will give and take in terms of financial aspects or ideologies than the strict legal rights as determined by the law of contract. Now, 6 approaches. Which approach is more favorable in your opinion? Okay, why? Why do you think that chosen approach is more favorable to you? Any questions? You know where to find me. Thank you. Assalamualaikum warahmatullahi wabarakatuh.